Good morning, ladies and gentlemen. Our first case this morning is 2019-1247, 2019-1309. You will note that Justice French is not on the bench this morning, and in her place is Judge Pierre Bergeron from the First District Court of Appeals. Welcome, Judge.
Thank you.
For the appellant, Mr. Hardwick.
Thank you. And may it please the Court, Chief Justice O'Connor, I'd like to reserve 3 minutes for rebuttal. The definition of sexual predator in Ohio under Megan's Law has always meant a combination of two things. First, if someone who has committed a list of specified sexually oriented offenses, and second, a finding that that person poses a risk to reoffend. Now that has stayed the same from the time Megan's Law was enacted in 1997 through the substantive amendments in 2003 up until it was replaced at the end of 2007. Now, the question then becomes, how do we deal with people from out of state? And the General Assembly in 2950-09F2 has given us the answer. It tells us we need to look at the requirement of the other jurisdiction that the person register for life and compare it to the classification as a sexual predator in Ohio. Now, this isn't simply an abstract look at only the specific registration duties in Florida and the specific registration duties in Ohio. In some ways, it's more broad than that. In some ways, it's more specific than that. It's more specific.
Let me interrupt you for a second. Are we dealing with Megan's Law, or are we dealing with Adam Walsh Act, or does the analysis matter?
This is a Megan's Law case, and from the beginning, the Attorney General's office, who's been the lawyer for the state from the beginning, has said that this is it's a Megan's Law case. They argued that in the trial court.
But is that correct?
Yes, it absolutely is correct, and I also think it is highly improper for the state to try to change the game in this court for the first time. This court said in Dangler that they shouldn't be allowed to do that, and this is like me coming to the court saying, well, I've argued in the trial court that my client's conviction should be reversed. I know it was a hearsay argument there, but I'd really like to raise an Eighth Amendment claim now.
The applicable law at the time is what it is, whether counsel got it wrong, whether the underlying courts got it wrong. So regardless of what the argument was, if the incorrect law was applied, should we note that? Should we correct that?
Well, two things. First of all, in some ways, for my future appearances before this court, I would love an argument that allowed me to change theory so radically between the trial court and this court.
But it's not a change of theory, it's the applicable law.
And I do also think this court, this court has been very clear in drawing a line in the sand that's January 1st, 2008. And anything that comes before that has been Megan's Law. Anything comes after that is Adam Walsh Act. This court has never made an exception to that.
So, Mr. Hart, what is the thing that we're talking about? Is it the offense, or is it the duty to register once moving to Ohio?
It's the offense, and it's the fact that this court held in Williams, Adam Walsh Act imposes a criminal punishment. So now what the state is arguing is that Ohio, not without a judge or a jury, Ohio is going to, out of the ether, impose a criminal punishment for an act that occurred in another state before the law existed. There are so many constitutional issues with that if this court really thinks that's the issue, I suggest supplemental briefing only on that point.
Because Mr. Hardwick, didn't we already cross that bridge in Vaughn? Didn't we answer almost this exact question in that case?
Yes, yes, and Vaughn and in Bruce and in Williams, you drew the line at January 1st, 2008. And if you didn't, you'd have all sorts of constitutional issues. In fact, in some ways, it might be better for my clients to draw the line that way, because then the system collapses on itself and they have no duty to register, because all of a sudden now we're imposing a criminal punishment for something that happened before the law came into effect in another state that wasn't a violation of Ohio statute. And also there's the privileges and immunities clause issues if we're going to treat Ohio residents differently than we treat people from out of state. An equal protection issue, which my friend on the other side raised in their brief said, yes, we'd have an equal protection issue if we treated them differently. And that, so in some ways, I'd say throw me in that briar patch. I would love to be in Adam Walsh Act land now, because that would mean my clients have no duty to register, and it'd be gone, because there'd be no defaults. There'd be no Megan's Law for them to be defaulted back to. So in some ways, that would be good for my clients. But focusing, and also I just point out that I find that the Attorney General's office has also been advising sheriffs of this all along, and I think there's some. I think this shows some specific deficiencies in that office. If that office so misunderstood the law for so long and enforced it what they think is the wrong way, and all of a sudden, when it gives them a litigation advantage, they change their position. I think that is a significant issue. But if I can go back to the classification scheme here and talk about how we don't just look at the registration requirements and the duties in the abstract. 2905 09 F2 specifically talks about the offenders. They said they look at the actual offender and then look at the classification as a sexual predator in Ohio. And classification includes the process of being classified. And that definition, and that's important, because if you had someone in Florida who is automatically classified as a lifetime registrant without any finding that they pose a risk to reoffend, but in Ohio, the classification requirement is that they can only be classified as a sexual predator if they have a risk to reoffend, and they actually don't have a risk to reoffend. We can't say those statutes are substantially similar.
But then but that's the whole purpose of F2, is it gives you the right to challenge the similarity of the two statutes. So you challenge that and then you prevail. I mean, why isn't that your remedy?
Well, first of all, the trial court, and everyone agreed in the trial court, and that Mr. Lingle and Mr. Grosser had the right to a hearing about the statutes in general. The issue that the trial court, that they disagreed on, was when the trial court ruled, as all the other appellate districts have ruled, that said that Mr. Lingle and Mr. Grosser get to, at the hearing, present individual information that they don't pose a risk to reoffend. And that is the issue that was certified under Civil Rule 54B, excuse me. I'm a criminal practitioner dealing with the civil rules, but it was certified, that was the one issue that was certified as that there was no just cause for delay. And if we didn't do that, as those courts have ruled, the General Assembly has said that the purpose of these classification schemes is to register the people who pose the most risk with the highest responsibilities, and so that we have more protection, and that defies that rule. Also, importantly, the difference between a system in which a person is classified based on offense only, and then to classify to such severe registration requirements every 90 days, 3 different places, in person. The difference between that being a risk-based decision and just a pure offense-based decision, that's the difference that made Senate Bill 10, Adam Walsh Act, punitive. That's, according to Williams, what pushed it over the edge, starting at paragraph 17. That was the factor that this court helped push it over the edge. And so if this court, all of a sudden this court, now we have a punitive statute. If that is the correct interpretation, now we have a punitive statute that can't be applied retroactively. I also say that's also consistent with what the solicitor's office told this court in Williams when they said, quote, the major innovation of SB 10 was the automatic classification scheme, is what the solicitor's office told this court when they were arguing Williams. That is the critical difference. And if we don't have that individual risk assessment, then again, we have a punitive statute that can't be applied retroactively, and we complicate things even further. The other thing...
What about the statutory language, Mr. Hardwick? The language seems pretty clear and doesn't seem to support your argument. So help me understand how we get to where you want us to be from the actual language of the statute.
Well, the language of the statute, first of all, it brings in the individual person, because it says the requirement of the other jurisdiction that the offender register as a sex offender. So we're looking at what this offender was and what happened to these specific people. And then it also then looks at the entire, it doesn't just look at, as the state would like us to, only at the registration duties. It looks at the classification as a sexual predator in Ohio. And what is that classification you have in Ohio? That includes a finding of that they are.
Well, what it says is that the requirement of the other jurisdiction that the offender register is substantially similar to a classification as a sexual predator for purposes of this chapter, which seems to tie the registration requirement itself to the substantially similar language in the statute.
But it's not. But it's the way the General Assembly drafted it. It's not. I guess with a lot of things with sex offender registration laws, it's not the most artful way of doing drafting a statute, because on one side they said the requirement to register, on the other side the classification, which in some ways you have apples. They said compare the apples to the oranges. So it is broader than, but it is broader than just looking at things in the abstract, partly because, again, they bring in the word of the offender. It's not just what that statute says, it's how it applied to that specific person. And in the cases of Mr. Lingle and Grosser, their lifetime registration was imposed on them without any regard to risk to reoffend. And one of them initially got probation, the other one got 6 months in jail. And these weren't people that their local judges thought were serious risks to reoffend. You don't get probation.
Counselor, was the duty to report in the state in which they were convicted similar to Ohio's?
It was. I'm trying to remember. I believe it was twice a year as opposed to 3 to 4 times a year. So there is some, and they had no community notification, which they now get in Ohio. Plus, they have, and one thing they have different there in Florida is after 25 years, they can seek to get themselves off the registry. And because that's one issue that didn't get resolved in the trial court.
Okay, but it would classify as substantially similar. The obligation to report for an extended period of time, whether it's twice a year, 3 times a year, 4 times a year, is still a duty to report for a significant period of time.
Well, I agree that it's still a duty to report for a significant period of time. I would argue that differences in, for instance, community notification make an enormous difference to the quality of someone's life under this. And the difference, and I guess now we have there say 2 times a year and 4 times a year, but that 4 times a year was another one of the reasons that troubled this court in Ferguson, and that almost then turned it into a punitive matter. And then Williams said, look, showing up 4 times a year is not even close to being a driver's license. So there is a big difference there.
Counsel, they were substantially similar in the reporting requirements, but were they substantially similar in how they arrived at that classification?
No, Your Honor, they're absolutely different in how they arrived in that classification, and that is part of the statute. The statute could have just said we're going to compare the registration duties in one state versus the registration duties in Ohio, or they didn't say that. They said to the classification, and that is not just registration duties. And I just want to come back to the definition. The definition has never changed. We are trying to say, did the legislature intend for sexual predators, someone to be labeled a sexual predator if they didn't pose a risk to reoffend? And if they truly wanted someone not to, that sexual predator no longer mean what it says. And think of even the word sexual predator. That includes someone who's going out and trying to imply someone who's going out in an attempt to hunt down and commit new sex offenses. That's even in the title the General Assembly has created. That to impose that without, and also I said this court has held, and this court held in Lloyd, the purpose of the registration statutes is to give heightened scrutiny to people who deserve and need heightened scrutiny. All of that is thwarted under the state's interpretation of the statute, and that's why Mr. Lingle and Mr. Grosser should have a chance to prove that they do not pose a risk to reoffend, and why it is violates both the statute and constitutional provisions to require them to register as a sexual predator even when they have no risk to reoffend. Thank you.
Thank you. Mr. Hendershot.
Justice O'Connor, and may it please the court, as you heard from my friend on the other side, there are two distinct paths to analyze this case, both under the Adam Walsh Act and under Megan's Law. Now, I recognize that we raised this Adam Walsh Act point very late in the litigation. We did so under what we view as a duty of candor about getting what the correct law to apply the situation right. And all acknowledge as well that the advice the Attorney General's office has given to sheriffs, of course, are not their clients, but has been a descriptive thing instead of a proscriptive bit of advice. And so that is all out there. And I recognize that it may be that because of the way this litigation is unfolded, that the Adam Walsh Act, you consider it off the table. So I won't dwell on the Adam Walsh Act unless there are specific questions, although we've extensively briefed why we think it is the correct path to analyze these kind of out-of-state moves when the move is after January 1st, 2008, which is the effective date of the Adam Walsh Act. Now, if we look to the Megan's Law, there are three reasons we'd ask you to affirm what the 10th District did. Now, my friend said that the question before the Common Pleas Court, there's a lot that everyone agreed on, including the 10th District, and that is that there's a comparison of Florida's registration system to Ohio's. That's going to happen no matter what happens in this court. The question here, and the question the 10th District disagreed with the Common Pleas Court about, was whether that will also include a question about the recidivism risk today. That's 30 years later for Mr. Lingle, and I think 14 years later for Mr. Grosser. So that is what will be different in the Common Pleas Court if you accept my friend's position here, what the Common Pleas Court did, which is to add something that frankly isn't in the statute. And I can't really do much better than what Judge Bruner wrote for the 10th District in that decision, saying that the words that Lingle and Grosser would need to have in the statute are simply not present. That's at paragraph 31 of her opinion. And what are the words you'd expect to see there if there were a recidivism hearing? Remember, we're looking at what used to be subparagraph F2 of 2950.09. The words you'd expect to see there are the words that are over just a few pages earlier in subparagraph B. 10 factors for a judge to consider to do this evidence-heavy sociological prediction about future risk. There's also details about the prosecutor's participation, the right to call witnesses, including experts, and the right to cross-examination. Not one of those things, not one of those 10 factors, not one of those procedural mechanics is over in subparagraph F2. It instead directs a statute book to statute book comparison of the requirement to register. Things like, how often do you check in? Do you check in where you reside and also where you work and also maybe where you go to school? Do you check in with the BMV to register your license plate and VIN number? All of those things, at least under our reading of the Florida law, are the same. So that's statute book to statute book comparison. And that is, again, that question is going to be decided either way, but that's what the statute asks the court to do. And that
under that view, why then is there a clear and convincing evidence standard? If we're just doing a legal comparison, why does the statute have this evidentiary kind of burden?
Well, recall, Your Honor, that the statute doesn't just apply to other states like Florida, and there's quite a bit of similarity state to state because of the federal SORNA law now. But this statute also covers if you had a registration obligation on a Native American reservation or in another country. And so in those cases, you might need an evidentiary standard to understand what the law of the other place is. And it may not even be statute law. Sometimes it could be regulations. It could be something else, depending on where you're coming from. But the key words of the statute, the requirement to register, comparing that to the status as an offender, that we think is still a law-to-law comparison. And it lacks, other than that one thing, that clear and convincing evidence standard that I think probably is there because it's not just other states you're dealing with, you are missing all of the other indicia of it being a recidivism. All of the 10 factors in now repealed subparagraph B, the portions dealing with a prosecutor's participation and calling witnesses and calling experts on the right to counsel, all those things.
But if a court is conducting that hearing to evaluate this by clear and convincing evidence, are you saying the court would be prohibited from considering the likelihood of recidivism?
Yes, there would the statute does not authorize the Common Pleas Court to evaluate recidivism today, which is 15 or 30 years later for these folks. Instead, it's asked to compare the two systems and say, is the obligation under the here Florida to Ohio, are those, I guess it's phrased in the negative, not substantially similar, but the basic is to compare whether those are similar or not. And remember, someone in Ohio who committed their crime in Ohio and has lived here their entire lives does not have this ability to have a recidivism hearing years or decades later after their initial classification. Now, there was a time when that was true. If we rewind all the way back to 2002, that was in the statute. Whether you were in state, out of state, you could go back to the court and say, I would like to use those same mechanics, witnesses, experts, the prosecutor, and prove that now I don't have a risk to reoffend. But that was deleted from the statute in 2003, and it asked the precise question that Lingle and Grosser want the Common Pleas Court to ask. Are they now unlikely to commit a future offense? But that amendment took away the exact thing that Lingle and Grosser are saying that they have a right to now. So back to maybe the very beginning organization of what I wanted to spend time with you all on.
Counsel, isn't it in
I'm sorry, I'm not able to hear that question.
Looks like Justice Donnelly has frozen.
to have courts have hearings so that people that aren't truly sexual predators don't get classified as such, so that the real sexual predators in the state of Ohio are not diluted in the sea of people who shouldn't be classified as such. Why wouldn't the state want to advocate for that kind of transparency and having hearings and evidence-based decisions?
Your Honor, I want to apologize up front. At the very beginning of your question, you were frozen temporarily. I think I understand the point of the question, but if I'm not covering it all, please interrupt me.
I apologize.
No, I apologize as well. So for this format, I wish I were there in court with you all. So this is really not something that is a choice for the Solicitor General or a choice for courts to make about what is the right thing to do in terms of what does this look like? What kind of hearing should be? That's something the General Assembly has decided. And my friend keeps pointing back to the definition of sexual predator, which is true under Megan's Law, talked about the risk to reoffend. But remember, of the two basic structures that you see across the country, 35 or 36 look like today's Adam Walsh Act. The other look like the old Megan's Law. All of them are aimed at the risk of recidivism. Take a look what the U.S. Supreme Court said in Smith versus Doe in 2003. They said, the offense itself can be a predictor of risk of recidivism. So it's really just a matter of how you go about making that prediction. And that's, the Assembly has made the choice. They made the choice under Megan's Law to say, if you're coming here from out of state with a lifetime obligation, as long as it's not substantially dissimilar, then you should carry that forward here. It's like a reciprocity, essentially. You will carry that same obligation forward into Ohio. And it's not that there's been no evaluation of recidivism, it's just that Florida does it slightly differently, or it did at the time. Well, now there would be, of course, if you do the Adam Walsh Act version, they look exactly the same. And so it's really not a matter of anyone else choosing what is the most transparent. And the Assembly has made that choice. And of course, there are bits of pending legislation that would modify the existing Adam Walsh Act and the ability to get off the list and so forth. Those are things that continue to be debated in the legislative branch. Justice Donnelly, did that cover everything in case there was some piece that I didn't catch when you were frozen?
Yes. Just your friend on the other side mentioned that these two offenders have lifetime appointments in Florida, but their sentences, I don't know the underlying facts, but it would reflect that they must not have posed too much of threat if one received community control and one received 6 months, and now they're going to be without the ability to challenge that at a hearing, labeled a sexual predator in the state of Ohio.
Well, that was the judgment that was made under Megan's Law by the General Assembly. Now, frankly, it's one reason that we think the Adam Walsh Act is a superior way of looking at this. And we think that is what the Assembly has said. As long as you move here after 2008, use the Adam Walsh Act. And I won't continue to push that. I recognize the issues of us raising it so late in this litigation, but that does result in different outcomes for folks like maybe not Lingle and Grosser specifically. That hasn't really been briefed out, but it may, for many people, they would end up worse off under Megan's law. So of the three things that I was hoping to cover about reasons to affirm, remember the narrowness of what the 10th District did, which is to say the Common Pleas Court will not, in addition to comparing the registration systems, make a present day 2020 evaluation of the risk of recidivism. So on that, all the language we've talked about is missing. That's the first point. The second is it would look exactly like a kind of hearing, far divorced from...
Before you go further, real quick, let me ask this. Why wouldn't a present day evaluation be more appropriate for risk of recidivism?
Well, again, that is something that the Assembly has made the judgment of not having a much later in time evaluation of recidivism, that whatever the other state system did to evaluate recidivism was enough. It's similar to the judgment that they plainly made in 2003 to delete the later in time recidivism evaluation for everybody. That was in old subparagraph D, where pretty much year after year. Sorry, I thought you had to follow up there. It's a little bit.
I was trying to hear your answer and trying to get my question out at the same time. So go ahead, finish.
Sure. So I think that really points up that Lingle and Grosser are asking for the exact thing that was specifically deleted. If you look at old subparagraph D, it said the court should look at the question, is this person in front of me unlikely to commit a future sex crime?
And if you've gone into the future, then you've seen whether that has panned out, whether that recidivism prediction has validity.
You have, and that might be a very good reason for the Assembly to consider policy changes in this area. But they made the judgment that, on balance, having over and over these reevaluations, and that's, it was deleted in 2003 for a reason, and it was that there's been some kind of evaluation at the front end, and that's going to be the system that we have. Then there'll be limited opportunities. Instead of everybody having the opportunity to petition off, they'll be limited to certain tiers or certain situations, and that's the system that we have now, and the system that was in Megan, at least the Megan's Law version, in place when this case, well, not when this case arose, in place right before the Adam Walsh repealed all of that. One last thing I didn't touch on that my friend did mention was he wants to point to the definition of sexual predator and say, well, look, that talks about the risk in the future. But the definition in subparagraph F2 to focus on is adjudicated as a sexual predator. And that, if you look back at 2950.01G5, includes, if you're adjudicated a sexual predator, it includes the specific thing we're talking about here, which is you were adjudicated in another state as a consequence of just the crime itself, you have an obligation. And then the only question left over is, are those registration systems substantially similar or not? One last thing, I'll largely direct you to the brief, and that is that there would be, if you give only non-Ohioans this opportunity to have a much later in time recidivism evaluation, it at least raises the specter of an equal protection problem. And under principles of constitutional avoidance, that just stacks one more reason on top of the absence of all these procedural mechanics and the specific deletion of this kind of hearing in 2003 as a reason that the 10th District got this right. By limiting
how would that be an equal protection problem? Because those people moving into the state at a later date could never have had any sort of adjudication or hearing beforehand. So giving them a hearing once they move in wouldn't seem to me to create any sort of equal protection issue.
Well, Your Honor, I would point to what the Third Circuit did in the brief, this case that we cite in our brief, where they did compare in and out of state offenders. So all we're saying here is not that it would definitively be an equal protection violation, but that it is something that under the canon of avoidance is something to take account of. And again, layering that on top of both the absence of all the procedural language and the specific deletion. But I think the problem that could arise, and why it's at least a possible issue under equal protection, is that only non-Ohioans would have this opportunity for a hearing years removed from the offense. Everyone in Ohio would not have that opportunity, and that's the differential treatment that at least raises the specter of that issue. So, Your Honors, as the clock ticks down here into the last couple of seconds, I would just wrap up by saying that What Lingle and Grosser ask you to do, as Judge Bruner said, is to put words in the statute that aren't there, and would put words that would make Ohio at least sort of a clearinghouse as a place where sexual offenders would come, because it might be the only place they could move to and get this kind of hearing that I'm not aware would be available anywhere else. Your Honors, for all of these reasons, we would ask that you affirm the judgment of the 10th District. Thank you.
Mr. Hardwick, you've saved 24 seconds. We'll give you a full minute.
Thank you, Your Honor. The state keeps talking about how people shouldn't have a chance to come back and get a second evaluation after the fact. We just want one evaluation as to the risk. Mr. Lingle and Grosser just want one. And the statute itself.
Counsel, do similar situated Ohio offenders get the opportunity to have a hearing such as your clients are requesting in all designations? For
sexual predator, with one very small exception, yes. There are some, if they are indicted with a sexually violent predator spec, then no, they don't get a hearing. Other than that, other than a jury finding of that, yes. No, everyone who committed an offense in Ohio under Megan's Law gets a hearing where they have a chance to show that they do not pose a risk to reoffend.
And when do they have those hearings?
They have those at either at sentencing, or sometimes they are years after the fact. If they committed their offense, they have a chance. There's a chance to do the sexual predator hearing before they're released from prison if they didn't have it done initially. But they can. So it can be some cases years after the fact.
But it's for the most part on the front end, not years later. If someone is in the community.
Yes, but it is done, and that there is a much bigger difference between being required to register as a sexual predator for life every 90 days with potentially 3 different sheriff's offices, and to do that without even ever having a chance to prove that that's necessary. The General Assembly has said that they want to give more resources towards more dangerous people, that they want to focus on the dangerous people. That's what the state's interpretation doesn't do.
Thank you. Thank you, gentlemen. We will take your matter under advisement and let you know of our decision.